Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Ma'am, what's your name?
Rakaya Boyd.
Ms. Boyd, I'm Magistrate Chardea, ma'am. You're here on a criminal matter. Case number is 240-5704-501, ma'am. You have an attorney?
Janet Stevenson appearing on behalf of Rakaya Boyd. Stands mute, waives the reading of the information as to the plea of not guilty entered on her behalf. Ms. Boyd has been advised of her rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are May 13, 2024, probable cause conference, followed by preliminary examination, May 20th, 2024. Both matters are in front of Judge Ms. Boyd. While this case is pending, there's some bond conditions, ma'am. You're not to possess any firearms or any other dangerous weapons. You are not to have contact with a Malik Johnson O'Brien. That means no person-to-person contact, ma'am. No contact with third parties, no phone calls, no emails, no text messaging. Also, you're not to go back to the Nashville address. Do you understand that, ma'am?
Yes, ma'am.
Okay. Counsel Stevenson, does she need a police escort?
Yes, Your Honor, please.
Okay. So, Ms. Boyd, okay, you're going to have a one-time opportunity with a police escort to go to the Nashville address to get your belongings. Do you understand that, ma'am?
Yes.
Thank you. Counsel Vincent, go ahead as to bond.
Judge, respectfully, we're asking 20,000 cash as surety. We're asking for monitorization, allegedly as a direct result of some type of cheating allegations. The defendant took it upon herself to throw some type of tool, assumably it was a screwdriver, at the individual, causing a gash in his arm. Then she ends up getting a knife and stabs him. Had to be brought to the hospital, Judge. Now, here's where it gets even more interesting. You know, I may have asked for less, but for the fact that apparently there were multiple witnesses here, one of which said they saw the defendant stab the complainant, another of which said after the stabbing, they ended up seeing the defendant try to run the complainant over. And then we have another witness who says that she ended up calling that individual and admitting to the fact that she stabbed him. So we do feel as though there's a high likelihood of conviction here, highly assaultive, respectfully $20,000, cash surety, tether, some type of monitorization charge.
Go ahead, Counsel Stevenson.
Thank you, Your Honor. Unfortunately, it looks like due to the fact that Ms. Boyd, I think, has recently had a baby, there may be some mitigating circumstances or some other factors that the court would have to take into consideration in fully assessing this situation. Ms. Boyd is 24 years old, Your Honor. I'm not aware of any prior criminal history. People can correct me if they have some different information. I don't have anything showing that Ms. Boyd has ever had to go to court before. She's in school full time. Again, she has been dealing with some postpartum issues, Your Honor. No good reason for her to have contact with the complaining witness at this time. We're thanking the court for allowing her to retrieve some personal belongings from that location, Your Honor. She's gonna probably be staying home with her mom, which is a good idea at this time. I'd ask the court for a very, very, very high personal bond. Give Ms. Boyd an opportunity to get back to her very young child, Your Honor, and not further exacerbate any mental health issues that she's dealing with at this time.
Thank you. This court has heard the representations from both sides and regarding Ms. Boyd, using clear and convincing evidence standard when it's entertaining a monetary bond in reference to Ms. Boyd is that not only allegedly in the allegations is that there was allegedly an assault with a knife and there is with a motor vehicle. And then as well as witnesses indicating that Ms. Boyd had committed some acts against the complainant, Mr. Johnson O'Brien. This court has concerns because it's not one, okay, but it's more than one incident, even though it's the same day. So it's not like there is, let me do one type of assault, then move on to another type of assault. Okay. This court believes that Ms. Boyd is a danger. Court is going to adopt the $20,000 cash surety. Court is also going to put a GPS tether. Court will allow for school only, because this is what the court has heard, that she is attending school. The court does believe this is unaffordable. Is that correct, counsel?
That's correct, Your Honor. What was the amount of the bond again, please, Your Honor? I'm sorry.
That's okay. $20,000 cash surety. She's going to get an unaffordable bond redetermination court date for this Monday, May 6, 2024, 9 o'clock in front of Judge McConicle, who's going to review the bond amount and bond conditions.
Thank you, Your Honor.
Thank you.
Thanks, Judge.
Thank you, Ms. Boyd. You can step aside.
Several days later.
The young lady on the 8th floor, can you hear me? I put you on mute. There's a little background noise. I'm gonna actually unmute.
Yes.
Ma'am, can you tell me your name?
Rakaya Boyd.
All right. This is State of Michigan versus Rakaya Boyd, case 24057-04501. Today is the date set for a bond redetermination hearing. Appearances, please.
Boyle appearing on behalf of the people.
Bring it on behalf of Ms. Boyd, Your Honor.
All right. Today is the date set for the redetermination hearing. Mr. Reagan Esteban.
Ms. Boyd is 24. She is a full-time student right now. She's going to school every day, Judge. She has 2 kids, lives in the Metro Detroit area. Judge, obviously, you know, this is a domestic situation. We're going to obviously say no contact with the complaining witness. Again, she has no prior criminal history, Judge. Suffering postpartum depression right now a little bit, Judge. But again, no contact with the complainant. Obviously, you know, it's a serious situation because it's charged as such. But I think that the court, if the court was to issue a tether, no contact, I think the court could use a less restrictive measure since she has no prior criminal history. So I'm asking the court to reduce the bond to personal bond with those conditions, Judge.
All right, Ms. Coyle.
Your Honor, I think the bond, again, another case where, I mean, I guess we start dismissing these cases thinking that they're, just because they're domestic, they're not important. And this is highly assaultive. This is allegedly, there's 2 instances here. She stabs him allegedly, and then tries to run him over when he's on the ground. And so there's two incidences within this. We also have, outside of the complaining witness, Mr. O'Brien, we have 3 witnesses that saw not only the defendant stab the complainant with the knife, but also heard the complainant say, "She stabbed me." They saw the defendant try to run him over. Another witness called him on the phone and she stated, "I just stabbed Malik in the leg. I just snapped. I don't know what happened after that." So that's powerful evidence in a future case, but that's also says she couldn't control her actions. "I just snapped and I don't know what happened after that." That's coming out of her own mouth, allegedly from a witness who relayed that to the police. We also have the knife recovered, and very strong again is the admissions by her. And Your Honor, I think the bond is frankly very appropriate considering the circumstances, even though she doesn't have a prior criminal history. This is extremely assaultive. When she didn't, she went, and I think this is the case where she got a tool from a toolbox and threw it at him, cut his arm, and then he goes home, and then she gets a 7-inch kitchen knife and then stabs him again. So at this point, Your Honor, I think that bond, frankly, is generous, because I think that bond should be $20,000 cash myself. And the judge, also the magistrate, gave a tether which would include her to be able to go to school. So Your Honor, for these reasons I've enumerated, I think the evidence is strong and the assaultive nature is high. They have a child in common, which it makes it even more volatile in the situation. Your Honor, so I'm asking for that bond to at least remain. And I don't know what the circumstance of her school, but if she can make that bond, I guess finish out school, because school's just, it should be finishing this month. And of course, no contact, Your Honor.
And Judge, it may be powerful evidence, but it's only half the evidence, Judge. It's only half the story. We're reading something from a document where you get one side of it. You don't get the fact that somebody may have been attacking her and she may have been trying to do certain things, because it's written a certain way to try to get her charged with these crimes. And that's half the story. I think once everything comes out, Judge, it'll be a little bit more clear about the whole situation. Not just her stabbing somebody, not just her grabbing a knife. It'll be a complete picture, but you get half of it, Judge, with the investigator.
You know, I guess I'm not looking to try this case, but the fact that she got in her car and then went to try to finish and try to run him over, that to me is extremely frightening for the complainant. Not only is he injured, now she's trying to run him over. And the fact that she said that I mean, there are admissions. And so, Your Honor, I mean, I'm not trying to, like I said, not trying to try this case or anything, but I do look at it, this is highly volatile and extremely dangerous for the complainant.
All right, I've had a chance to review the investigator's report. These are my observations. I would note that the complaining witness and the defendant both live at the same address. This is an incident where there are at least two separate witnesses, as well as 2 separate time frames. And I would also note that the that the defendant does not have any previous record. And the admission that I have is something to the extent that she snapped. So I do believe that there might be a mitigating circumstance here or something to that nature. But the fact of the matter is I can't, I do believe that this is a highly dangerous situation, and whatever is going on, there's nothing that indicate that it's not going to stop right now. So I am going to keep the high cash bond. I do believe that it's appropriate, and there's clear and convincing evidence that there are that a high cash bond is the only way to ensure that the complainant is safe right now. Mr. Reagan, I know you're not keeping this case, but if there are circumstances or things to put in place, please let the next attorney know so we can get this bond modified at the next hearing date.
Yes, Your Honor.
All right, bond is going to remain the same.
Thank you.